Hi guys, welcome to Commercial Law Tutorials. Law of purchase and sale. This is our first lesson. We are going to look at the definition and the essentials. In this lesson, first of all, we are going to define the law of purchase and sale. Then we'll also talk about the essentials. And at the end of the lesson, I'm going to give you popular exam questions relating to this lesson. The definition. Purchase and sale is an agreement or contract in which one person promises to deliver a thing to another, who also promises to pay a certain price for that thing delivered to him or her. So it is a transfer of possession of a thing in exchange for a price. Thus, an agreement to make over to another a certain thing for a certain price. That is purchase and sale. So, expanding on those definitions, we can say that this is whereby the seller is obliged to deliver goods, transfer ownership in the goods to the buyer, and receive payment, and whereby on the other hand, the buyer is obliged to also pay the seller, receive delivery and ownership in the goods in accordance with their agreement. The highlighted points here forms the essentials of purchase and sale contracts. Let us look at the essentials of purchase and sale contract. We have agreement, the Merx or thing being sold, price, and delivery. I will explain this in detail. First, agreement. Agreement is a mutual assent between the buyer and the seller. It is the union of two minds in one direction as required, that is, consensus ad idem. And the buyer must intend to buy and the seller must intend to sell in their agreement. For instance, if one is buying bread in a shop, truly the baker would have made thousands of loaves with the intention to sell, and those buying the bread really needs the bread for their meals. So seller is willing to sell while the buyer is willing to buy in this example. That is agreement we are talking about. Then Merx or a thing being sold. There must be a Merx or a thing being sold which forms the subject matter of the contract. We can't have the contract of purchase and sale without the Merx. Note that Merx is usually divided into three topics. That is, Merx or a thing that is being sold must be ascertainable. Ascertainable goods are those goods which can be specifically identified in accordance with the agreement after the contract of sale is made. For instance, a white golf t-shirt with a green bow on the pocket. So when Merx is ascertainable, parties know what is being sold. For buyer has to buy and seller has to sell the thing they all know. This also relates to the amount, number, and weight of the thing being sold. Then secondly, future goods not yet in existence but whose future existence is anticipated may also be sold. For example, out of stock items. Then lastly, certain things cannot be sold. Res extra commercium. These are things that cannot be appropriated or ascertained, hence incapable of being owned also. Therefore, they can't be sold. For example, air. Then we have res nollis. They are incapable of being owned, for instance, birds and wild animals, unless they are tamed. And we have public property, for instance, street lights and roads. and poisonous or intoxicating liquor, firearms, and ammunition. Those are sold under strict restriction by the state. Inherited property under a will can also not be sold if they contain a prohibition against their alienation, but this can be sold if a relief is granted against the prohibition by the court. One cannot buy things which he or she is administering in the capacity of a trustee unless in a bona fide manner as a public auction or under an order by the court. For example, property being administered by an executor of an estate or an agent and these principals things, or in partnership, a partner cannot buy any property falling in the scope of the partnership. Then we also have the right of inheritance to a person still living. One cannot buy those. Any sale of such inheritance to a third party is void because it is contrary to public policies. Unless when the person is dead, the property can now be sold. Price. There cannot be a valid contract of sale without the price for the thing being sold. The price should be in the current money. For instance, one cannot sell a house in town in exchange for a farm in the rural area. This is a contract of exchange, not purchase and sell. So, the price should be in the form of current money. Current money here refers to banknotes, checks, money transfers, and other forms that are available. Then, the price should be a certain sum. A certain amount should be stated by the parties. The price should be definite and clear. That is like $20 or £100 for the product being sold. Thus, the buyer should know the exact amount he or she is going to pay for the product being sold. Then, the price also should be real. It should be proportionate to the value of the article being sold. The money being paid should be equivalent to the value of the thing being sold. That is what we are saying. Unless maybe if the product is on promotion. Then delivery. For ownership of a thing sold to pass to the buyer, the correct form of delivery must have occurred. We have actual delivery, constructive or fictitious delivery, registration, and cession. Those are the forms of delivery. More on delivery and ownership is also found in this channel. Now the questions. What does the law of purchase and sale incorporate? Briefly explain the essentials required for a sale to be under purchase and sale contract. Thank you so much for watching. Remember to subscribe and like.